Today I'm gonna be going over some of the laws and events that occurred in order for the bilingual program to get to the point in which it is currently today. Before the 70s, there wasn't really any bilingual program or any program that assisted those who did not speak English as their native tongue. Beforehand, students were expected to speak only English, and if they did not master the level of English that they were required to take, they would be held back. They will continue on being held back into either the student was removed away from the school system or the student learned enough English to get moved past to the next level. This started to change in 1963 when Coral, Florida received a abundant amount of immigrants, and since the immigrants came from Cuba, they mostly spoke Spanish. The program that was held in Coral, Florida was considered one of the first bilingual programs. And due to the massive success that it had, it started uh, it started to have influence in both federal and school wide. In 1964, the Civil Rights Act Title VI was passed. This title prohibits discrimination on the basis of race, color, and national origin in programs and activities which receives federal financial assistance. With the massive success of what happened back in Florida with the Cuban immigrants, in 1968, bilingual education started to become official. The Bilingual Education Act, which once again was passed in 1968, gave funds for bilingual programs. And also, the Bilingual Education Act received many amendments, but I'm gonna be covering three of them. One of the amendments was in 1978, which expanded the eligibility, which expanded the eligibility to students who are limited English proficient, and also it allowed for English speakers to be enrolled in a bilingual program. The Second Amendment was in 1982. This allowed for some native language maintenance, provided program funding for students with special needs, and also supported family English literacy and emphasized importance for teacher training. Also, finally, one of the amendments was in 1988. This increased the funding for state education agencies for special alternative programs where only English is used. It established a 3-year limit in which in most Title VIIs and created fellowship programs for professional training. For a while, the Bilingual Education Act or the Title VII Act was put to a halt, but all this was reestablished when the No Child Left Behind Act was passed or enacted. The No Child Left Behind was enacted in 2001, which reestablished the funding for for the for the bilingual program in other areas. To be more specific, the No Child Left Behind Act reauthorized Elementary and Secondary Education Act of 1965. It gave appropriate funds to improve education for those who had limited English by assisting them learn English and meet challenging state academic content and student academic achievement standards. The lingual program was also impacted based on Supreme Court cases. One of those Supreme Court cases was Law versus Nichols. Laws versus Nichols began in 1970. Case was because parents of a Chinese student claimed that they were at a disadvantage because the student could not understand the academic vocabulary and what they were being taught because it was purely based on English. Lower courts stated that the district was not held responsible, therefore they favored the district. So then the Supreme Court decided to take this case, and then they decided in favor of the plaintiffs, in which Justin William O. Douglas stated simply that There is no equality of treatment merely by providing students with the same facilities, textbooks, teachers, and curriculums. For students who do not understand English are effectively foreclosed from any meaningful education. The Supreme Court case was Plyler versus Doe. This took place in 1975. Or it didn't take place, but it began in 1975, where Texas legislature authorized local school districts to deny enrollment in public education to foreign children who were considered not legally admitted to the United States. Once again, the Supreme Court took over and they ruled that this previous law violated the 14th Amendment. The 14th Amendment states that no state shall deny to any person within its jurisdiction the equal protection of the law. Therefore, school districts cannot deny such an education to undocumented children without showing that it furthers some substantial state interest. Though not a Supreme case, a federal case that impacted the bilingual program was Rios versus Reed. This took place in 1978, where parents of a Puerto Rican children claimed that the so-called bilingual programs that their district in New York was offering was not in fact a bilingual but solely based on ESL. Also, they pointed out that there was a lack of trained professionals that were involved in the bilingual program. Although this law did not state any specific reasoning or any specific guidelines for a bilingual program, it did establish a strong case for offering bilingual education and for doing it correctly. And then finally, another case that stood out was the Castañeda versus Pickard case, which was established in 1981. This made it so that every district that offers a bilingual program passes something called the Castañeda test. This includes three categories: theory, practice, and results. The theory states that the school must pursue a program based on an educational theory recognized as sound or at least as a legitimate experimental strategy. Practice states that the school must actually implement the program with instructional practice, resources, and personnel necessary to transfer theory to reality. And finally, results. The school must not persist in a program that falls or fails to produce results.